Well, it is Tuesday, and I am back in the office. I was in Bucks County, Pennsylvania this morning. I was in Cape May County, New Jersey yesterday. Be back in Bucks County tomorrow, and then finishing out the week in Delaware County, Pennsylvania. So it's going to be a busy week for our law firm in Pennsylvania and New Jersey. Did come out with a blog article regarding assault. Most recently, there was an NFL player who was charged with assault in Tennessee. And while our law firm doesn't practice in Tennessee, we're only licensed in Pennsylvania and New Jersey, the laws are very similar with regards to assault and the elements of that particular charge. Now, it's important to understand that, as I detail in that article, an assault charge can be categorized as a simple assault, which is a misdemeanor in Pennsylvania. It's a misdemeanor in Tennessee. It is typically a disorderly persons offense in New Jersey. An assault can also be an aggravated assault, in which case it's a felony charge. In Pennsylvania, it's a felony in Tennessee. And in New Jersey, it is what's called an indictable offense, an indictable crime in New Jersey, and can be graded as a crime of the first, second, or third degree. So it's a serious offense in both Pennsylvania and New Jersey, as well as Tennessee. It's a felony grade offense. Now, with that said, this particular NFL player was not charged with felony assault. He was charged with simple assault. And it's my understanding that he pled it down to what's called a Class B felony. It seems like he was charged with a Class A felony initially. Now, Pennsylvania doesn't divide up misdemeanors that way. It kind of does. We don't call them Class A or Class B. We call them misdemeanors of the first, second, or third degree. And in Pennsylvania, typically a simple assault is graded as a misdemeanor of the second degree. In some cases, it can be graded as a misdemeanor of the third degree, where it is a fight which occurs because of some mutual scuffle, as the law defines it. Now, with that said, this particular NFL player, I believe he's a linebacker with the Tennessee Titans. He pled guilty, received 6 months of probation. It's probably non-reporting probation. I'm actually surprised he wasn't eligible for some kind of diversion program. I don't know if he has any criminal history. I doubt that he does. But in this particular incident, he was not charged with aggravated assault. The alleged victim in the case, we can call him the victim now since he's pled guilty, it's my understanding that they had some type of cut over the forehead, and there was some incident involving a phone. He was with people, but it's surprising that he wasn't eligible for ARD. Now, I don't know the circumstances surrounding the case, but typically in a assault type case, the consideration of the alleged victim has something to do with the ARD consideration, so that may have been the case there. Possibly the prosecution would have only agreed to like an ARD or diversion program if the victim agreed to it. Now, I don't know. I can imagine that this victim is probably going to sue this NFL player for some type of civil lawsuit, and they would probably advise don't enter into or allow him to get into this diversion program, because it somehow shows that you're somehow comparatively negligent. I don't practice that type of law, but if it was my client, I'd probably do everything possible to maximize the civil settlement that he could possibly gain from that. But again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429, the website gambonelaw.com, a tremendous resource for you and your family. All my books, my blogs, my videos are available there in one convenient format. In that blog article, I also detail what makes an aggravated assault an aggravated assault. And also, an aggravated assault can be based on the person who was attacked. If the person who is a member of a protected class, there'd be a police officer, a firefighter, or an EMS person. In this particular situation, it was none of that. It was a convenience store worker. And while these are obviously people too, they don't have any type of special classification under the law, unlike a firefighter or a police officer who's acting in his official or her official duties. In addition, I don't believe that he had any type of self-defense argument. If he had one, the case could have gone to trial. In that particular case, it sounds like it was just a argument, and I think he's like 6'4", 6'5", 269 pounds. So he's a big man, and it sounds like it was a pretty one-sided argument. But in that article, I do detail what a self-defense argument is and how it is to be asserted at trial. And once it is asserted by the defense, if you don't assert it, you've waived it. But if it is asserted, the prosecution has to establish beyond a reasonable doubt that the person was not trying to defend themselves or another person from some harm or some kind of serious injury. But once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. In addition, each and every Friday, we come out with a weekly e-update. It'll go out this Friday. I'll probably feature this article. In addition, I'll be doing some other articles on drinking and driving. Crimes like drinking and driving, assault crimes. These are typical crimes in the summer months. People are out and about. People sometimes drink a little too much. There's gatherings, there's concerts, and things happen. Assault charges can happen to pretty much anybody. You see it in this particular player. This NFL player probably has no prior criminal history. Same with the DUI and DWI. So these aren't people who are typically committing crimes, but unfortunately, sometimes people make poor choices. But if you have questions, once again, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Have a great Tuesday, and I'll talk to you all very soon.